everybody, how's it going? And welcome back to Copper Jacket TV. So today I have a very important update for you in Baird v. Bonta, which is the case that challenges California's ban on open carry. Last month I made a video talking about an important decision by the Ninth Circuit Court of Appeals that actually reversed a district court judge's opinion that there should not be an injunction against enforcement of California's ban on open carry. The district court judge in that case basically took this case and said, well, I don't like it. I don't like open carry. I think it's dangerous. It doesn't really serve the public good. So I'm not even going to look at the merits of this case. I'm just going to deny the injunction outright without even really going through the process or the steps. And so that was a problem. That went up to the Ninth Circuit Court of Appeals. The Ninth Circuit said you missed a few steps here. You didn't do things correctly. We're going to reverse your decision denying the injunction, and we're going to remand it back down to you. And you have to do this expeditiously. We want to see a decision in this case very quickly because this case has been going on for about 4 years now, and the plaintiffs are still waiting on whether or not they can even get a preliminary injunction, let alone a summary judgment. So there's a lot going on here, and we have a new development as of just a couple days ago. So I want to talk to you guys about that because this could have some big implications on what happens next. Hey, I want to thank you all very much for watching. I really do appreciate it. We are on our final push to 500,000 subscribers on this channel, which is awesome. I can't tell you how much I appreciate every single comment, every single thumbs up, everybody who's ever hit that subscribe button. Thank you all very much for the support. It is really difficult in this specific realm and talking about the topics that we do to try and get anywhere on a platform like this. So you guys made that happen, and I want to thank you all very much for that. If you haven't subscribed yet, if you got an extra second, that would be fantastic. Let's hit that 500,000 soon. Let's get to the video. Okay, so let's go ahead and talk about what's going on here. So it looks like the district court is not just ignoring Bruin, but they're also ignoring the Ninth Circuit. Now, we know that the Ninth Circuit is not friendly to the Second Amendment. Everybody has seen what's happened recently in Duncan v. Bonta, which is the Magban case. I mean, they ignored processes there. They ignored their own rules and used the two-step approach instead of text, history, and tradition, and sided with the state of California yet again in another attempt to delay and deny people their constitutional rights. So we know that the Ninth Circuit isn't friendly, but the Ninth Circuit in this case at least did see that the district court didn't do its job before denying the injunction. So they again reversed and remanded the denial of the injunction back down to the district court. Now, this happened on September 7th, okay? It is now the 16th of October, and we have still seen nothing from the district court. Now, the district court was expressly told by the Ninth Circuit, we want to see something soon. We want to see something quickly, because it looks like, in this case, that the plaintiffs have a good chance of winning on the merits. And so the district court needs to take a look at that, and they haven't. Again, the district court is completely ignoring the Ninth Circuit and has come out with pretty much nothing at this point. Now, there are arguments set up for November 3rd in that district court for a summary judgment in this case, but that doesn't take away the fact that we have still been looking for an injunction until that summary judgment can come out. We have been looking for an injunction, and the court needs to address that. So the lawyers for Baird decided that, well, we're going to take this back up to the Ninth Circuit and make them aware that the district court is ignoring their order. And so what they did is they came out with this letter right here that they sent to the Ninth Circuit. And I want to read this to you guys because it's very interesting. Okay, so this is a letter addressed to the Ninth Circuit Court of Appeals dated October 11th, 2023 from the Bellatoni law firm, which represents Baird in Baird v. Bonta. So it says here, regarding Baird v. Bonta, your honors, I represent the plaintiff's appellants in the above referenced matter. By opinion dated September 7th, 2023, this court reversed and remanded the district court's denial of appellant's motion for preliminary injunction for failing to apply the proper preliminary injunction standard for a case raising a constitutional challenge. Specifically, the district court abused its discretion by declining to assess appellant's likelihood of success on the merits of their Second Amendment claim. The district court was instructed to complete its reevaluation of the requested preliminary injunction and issue a decision expeditiously, as this case has been ongoing for more than 4 years. The court may recall that the state's opposition to appellant's preliminary injunction motion contained no historical evidence. The state relied solely on public safety anecdotes to justify its regulations, which should have resulted in a prompt decision from the district court upon remand in light of the test in NYS RPA v. Bruin. 35 days have passed, and now it's actually been more, but it says here 35 days have passed since the court's instruction to the district court, yet no decision has been rendered. The parties are also in the midst of briefing their respective motions for summary judgment. The return date is November 3rd, 2023. Appellants post that the district court may delay determination of the preliminary injunction motion until the summary judgment motions are fully submitted and or decided. Appellants further believe that the district court may search for information outside the four corners of the preliminary injunction motion to reach its decision. Appellants respectfully request that the court issue further instructions to the district court accordingly. Thank you for your attention and consideration. So in California, the court system is stacked so hard against us that we have to now go back to the Ninth Circuit and say, hey, the court's not even listening to you, right? You're the highest court in California. You cover pretty much the entire western part of the United States, and the district court won't even listen to your orders. And we think what they're trying to do here is they're trying to delay us until possibly late November after everything has been filed and they have a chance to figure whether or not they're going to issue a summary judgment or not, in which case then they might tell us about whether or not they're willing to grant an injunction in this case or not. At the time of this letter, which again was at the 11th, at that time it had been 35 days since the court ordered the district court to come up with a decision expeditiously, which it has not. So in California, they ban open carry, which is clearly unconstitutional. With the laws surrounding concealed carry and being so difficult to actually do that, you need to have one form for somebody to be able to defend themselves in their constitutionally protected ways as they leave their home. In California, that is extremely difficult. So this court knows that, and they're simply denying everything up front, moving around with their activism and ignoring other courts' decision. They ignored Bruin. They didn't look at text, history, and tradition. They simply looked at, the two-step approach and public safety and states' interests and stuff like that. They didn't look at the merits of the case and whether or not the plaintiffs have a likelihood of winning on those merits. They just simply ignored all of that and said, we're going to deny your injunction. The Ninth Circuit, being the court that they are, or is really surprising, says, even you can't do that. So we're going to go ahead and we're going to send this back down to you, and we want to hear a decision on this really quick so that it can probably go back up to us, and then we can put a stay on the injunction, but at least you need to do your job so we don't look bad up here. And that's not happening right now. Now, with all of the press and everything being highlighted that's wrong with the Ninth Circuit right now, I actually think, and this is again just me trying to be optimistic, I actually think that the Ninth Circuit, if this judge is forced to grant an injunction in this case, and then California asks for a stay on that injunction with the Ninth Circuit, I think the Ninth Circuit, wanting to kind of move some of or shift some of its focus away from its recent decisions, might actually not grant that stay on the injunction. And so we could get lucky and see open carry allowed back in California very soon. I think in the end, I think we're going to see, Duncan and Miller and Baird and Rhodey and all of these cases, all of them are going to be overturned eventually. I think whether they end up at the Ninth Circuit en banc or whether they go up to the Supreme Court, I think we're going to be seeing a ton of wins in California very soon. But California is just really, really good, and the California court system is really, really good at delaying things and making things bounce around through existence, right? So I think we're going to see a win in these, but this particular one, we might see a win fairly soon. So, and hopefully so. The people of California have been without their rights for far too long, and it's time that the courts actually hold up the rule of law, which is written in our Constitution, instead of what their own activism tells them that they would like to see happen. Their own personal feelings and favoritism as the outcome, rather than, again, the rule of law, which they swore an oath to uphold and protect. So, again, it's just another delay tactic. This is all just delay tactics and semantics to get the outcome that they want. But the court is absolutely ignoring the Ninth Circuit. They're ignoring all precedent, and they're just doing what they want. That's kind of how things work in California, and it's sad to see because, they're supposed to be impartial, and they're not. And this is clearly showing you that they're not. So I wanted to let you guys know about that. I'm hoping that we'll get a response from the Ninth Circuit on this one soon, and the Ninth Circuit will tell that judge, hey, it's been a month and a half. It's time for the decision now. You need to come up with that decision, or else we will. That's what I want to hear. And we'll see what happens from there. But anyway, again, I wanted to update you guys on this case because I think open carry is at least an important part of our constitutional rights that should be addressed more often. So again, thank you all very much for watching. Please like, subscribe. You guys have a great day.